Welcome. Good evening. Good morning. Good afternoon, depending on where you're at. I'm Bob Mata. I am the host of Defense Diaries. Welcome, welcome, welcome. Still no Allie. Still no Allie. She is down there really trying to wrap some work up. I'm really hopeful that this is going to be the magical weekend, that this one project she's been working on for a very long time will come to an end. We can all hope, we can all pray, and that'll be great. So I'm going to try to kill some time because I gave you all exactly zero warning that I'm starting this live. I want to make sure that I started this live early enough to where I am done long before Dan and Steve start publicly buzzed, because I am notoriously eating into my brother's lives and I don't like to do that. So tonight I made an executive decision to go ahead and just start this thing, give nobody any notice. At this point, I got to be honest, you guys should really pretty much be used to me doing that, because I'm not great at setting lives like 2, 3 days ahead of time and then, you know, giving you guys all kinds of notice. Nah, I like to like kind of just drop them right there. All right. So if I'm a little bit preoccupied right now, oh, I see I'm going oppo of my girl Teresa over at Criminality. Damn it. Uh I don't like to go oppo of Teresa either, because I love her. Love Criminality. Love all the Criminality homies. All right, good. All right, so I got us portaled to PB, publicly buzzed, after I'm done. And I know that they're doing a reading. They're doing Teresa went through all the trouble, time, and cost of procuring the Delphi transcript. So I know they're doing a reading over there. So if you guys are over here, make sure you go check them out after, for Steve, and check out what's happening over there. It should be interesting. Get to hear all the stuff that you're not going to hear at trial because Gall denied it. Yeah, it's like I was going to go through a reading myself, and I figured, well, what's the point? Don't get to hear any of it at trial. So, uh, but it does give you background on what they put up and what she ended up denying. So, but my focus tonight, as I kind of got sidetracked today, is my earlier live went a little longer than I planned. I was trying to make that all happen in 2 hours, and I just couldn't make that happen in 2 hours. So I decided to boot. It's because I went on a very long-winded rant about just the state of affairs in our fine country, the U.S. of A., with respect to the school shootings and parents being charged and all that kind of stuff. So, um, yeah, that's one of those topics that just when I start going off on it, I just start going off on it. So tonight we're going to focus on Florida versus Laurie Shaver. And if you don't know anything about the case, I am hoping to remedy that this evening for y'all, give you a little background so that you kind of have an idea of what to expect when that trial starts next week, which we will be streaming here. And I think it'll be yet another just warped, just really disturbing case that is going to blow all of our minds. Oh, the humanity. Oh, the humanity, or the lack thereof, however you want to look at it. So Mandy and Dizzy have been busy all day, trying to gather some things for me to be able to give you guys some background. They've gotten some really good stuff together. And I think that the best way to start is to focus on the victim, Michael Shaver, a little bit. Uh, Dizzy just sent me something that looks like uh, somebody in his family, presumably a sibling, could be a parent, I suppose. Probably more likely than not, a sibling. Put together just like a 5 minute, just shy of a 5 minute tribute on Michael Douglas Shaver, who was the victim in this case. And I think that a really neat way to kind of get to know him and who he was would be to check this thing out. It should be pretty neat. So let's start with that. I think that that'll be a good way to get this ball rolling, and then we can shift gears and go over to the defendant in the case, his wife, and see what she is accused of doing. So let's pull this guy up here and get this guy started. I haven't even watched this. I'm sure it's going to be very touching. All right. Got it up here. Go full screen on it. All right. You guys can see that? All right. Okay. So rest in peace, Michael Douglas Shaver, 1982 to 2015, father, son, brother, friend. And then there's once you have tasted flight, you will forever walk the earth with your eyes turned skyward. For there you have been, and there you will always long to return. Pretty sage words there from Leonardo da Vinci, who wrote them long, long before we were able to fly as human beings. So, guy was way ahead of his time. We all know that. All right, so let's start off. Oh, and by the way, just so you all know, I set up the portal. So the portal, if I didn't already mention that, the portal to Dan and Steve. So make sure that you're hanging out there, but also make sure that you're checking out T too, because I'm sure they have a nice crowd over there. They're going through reading. You guys know how I love reading. Reading's so much fun. Somebody sent me a fan mail talking about it was a comment. Oh, more reading. Oh, no thanks. I'm like, wow. I mean, this dude does not know my channel. I'm big on reading. Reading is fundamental. Riff. You guys remember that? All right, let's go.
Oh, there I am. That's me. See, this is me in the mirror. I know you all want to see me.
Hi, I'm Michael Shaver, and I'm gonna do an interview. Here, come on over here. Okay. Now, tomorrow we are going to Atlanta, supposedly, and we will be going to Six Flags. We will be going to Six Flags in Atlanta, but we don't know which day. And we're not really sure yet, because we don't know how many fun things there are. And you see, my dad's trying to do some MTV kind of stuff. Sorry, Brian. I want to film.
Bring that baby home.
Is that hurting your arm?
It feels. Can you see the whole thing?
Yeah.
Even down here.
Yeah.
I built it all by myself.
Little drum kit.
You gonna play some more? Are you gonna sing?
Oh, wow. Is that good enough?
Yeah.
Cool. We came from right about there, where my fingernail is, and then we went all the way to right about there.
Yeah. Did you enjoy the trip?
Yeah, but it was a pretty stiff ride.
Was it?
Hello, Michael. What was that? Let's see that again.
What is that? Oh man!
Oh, yes! I know it! I told you.
What is it?
It's a radio.
Where?
CD?
Oh man! Where'd you get that?
You. Sharon, I think. And Christine.
Well, get it out. Let's check it out.
Okay. I'm like,
What?
yeah, you can. Don't just flip.
No. Michael's gonna do a flip now. Well, you gotta wash my hair first.
Tell me what y'all are doing.
Do it.
You got to explain to me what you're doing.
She's cutting my hair. And I'm getting a perm.
What's your name? Lady? Are you Miss Sylvia?
And I'm man. I'm man.
And I'm a favorite.
I am. Do something.
Hi, Mike. Tell me what you're gonna do tonight.
Wait, like go to see the.
Yeah.
Want to see me? You got it. Ready, set, go. Standing with my hands up.
Record the stupidest things, don't I? Goodbye.
Did you guys hear that Sinead O'Connor there in the background? Oh, that was awesome.
Put it down.
Drop it.
Turn around. Turn around.
You see this? It's coming.
Hey, that is not Michael Schaefer. That's whatever was on the YouTube after. So that was a beautiful tribute. Looked like a really sweet kid that came from a really loving family, close knit. So, all right, so there's a little background of his childhood. And kind of and here's how we're going to do this. So at that point, I think what I'll do is we'll swing right into the timeline, all right, of kind of how everything went down. All right, so I'm going to pull that up to give us an idea of exactly what has gone on since 2014 in this case. Our wonderful Mandy Joe put this together for us today. Did great work. All right, so we've got Florida, the state of Florida versus Laurie Shaver, victim, Michael Shaver, husband. So this is kind of the way it goes down, the broad strokes of what happened. So 2014, Michael Shaver is arrested on domestic violence charges. Michael states when law enforcement gets there that his wife was the aggressor. In 2015, Michael Shaver goes missing. And I think in between that time that they're separated. Okay. I think that they're living in different homes. There's an article we're going to pull up after this to kind of fill in a few of the gaps in terms of between 2014 and 2015. But I believe that I read that they had separated. He wasn't living in the house at the time that he goes missing. So in 2015, he goes missing. At that point, Laurie informs friends and family that her husband, Michael, age 36 at that point, has walked out on his family. Okay. And then this is where it starts getting really weird. So at that point, Michael's boss receives a text message from Michael's phone informing him that he's not going to be returning to work. And family members then start receiving text messages telling them to leave him alone. I've dipped. I'm out of here. I'm abandoning my family, my kids, my wife. I don't want to talk to my parents and my siblings. I'm out of here. I'm out of here. That tracks, right? That seems like, based on that video we watched, it seems like that tracks, right? Yeah, I'm being sarcastic in case you don't know. So then, and this is going on for quite a while with the text message initially. And then on his Facebook page, there's posts that are posted on his page as if he's the one actually posting certain things. And then from what we gather, it appears that Michael is likely killed sometime between November 7th and November 10th of 2015. Okay. And then in December of 2015, Laurie begins selling off Michael's belongings. Okay. So a mere month after he disappears, after he decides to abandon his entire family, Laurie begins selling off all of his worldly belongings. About a year later, 12/31, New Year's Eve of 2016, Laurie marries Travis Filmer, even though she's not lawfully divorced from Michael. And I'm assuming due to the short length of time from him abandoning his family, that he has not been declared dead at that point either. So sounds like little polygamy, maybe. Sounds like she can't be divorced at that point from Michael because she can't serve him papers because he's vanished. He's abandoned his family. All right. So in February, this is of 2018, February 6th of 2018. So this goes on for a couple of years with him allegedly posting to his Facebook occasionally. And then February 6th of 2018, somebody calls in a welfare check. And then when the law enforcement goes over there, oh yeah, bigamy. Thanks, Spitfire. Polygamy would be more. That would be multiple husbands. During the welfare check, when they noticed a concrete slab in the backyard that had been laid mysteriously in 2016, which I believe either had a fire pit and or a grill on it. I think it's a fire pit. On 3/9 of 2018, law enforcement gets a warrant because they have reasons to believe that Michael Schaefer's body might just in fact be under that concrete slab that was laid down in 2016. So they go in and tear up the concrete, start digging, and then Michael's skeletal remains are found An autopsy is performed, and the results indicate that Michael was shot in the back of the head with a 38 caliber. Now, obviously, when we go back up to this time frame in which the state is alleging that he was killed, they're having to guesstimate because obviously with the amount of time that has passed when his remains are recovered, they're skeletal. So in terms of being able to do anything that would physiologically be an indication for a medical examiner to determine a time of death on or around when he may have died, that there's not going to be much that they can do. So it's going to have to have been done by forensic data, eyewitness accounts when he was last seen, who spoke to him last, things of that nature. So August 17th of 2020, Laurie is arrested for second-degree murder and for being accessory to second-degree murder. And somehow she was allowed to post bail on this, and only 52 grand. That's a crazy low amount for somebody who's been charged with murder. And she does in fact post bail. So when we're watching this trial and everybody's asking, has she been in custody? The answer to that question will be no. She has been out and about. So, and this is where it gets like, if that's not crazy enough, this is where it gets really crazy. So on May 4th of 2023, the defense in that case, her lawyer files a bombshell motion claiming that, in fact, it was Michael's daughter, 7-year-old daughter, who had pulled the trigger and killed Michael. All right. So that's just the thumbnail, the Cliff Notes version of this case and what has gone on. And as far as this defense goes, I believe that one of the more recent rulings was that the judge denied a police interview from being played wherein I want to be sure I'm on it. I think that they're not allowing that defense to come in, or this statement that his 7-year-old daughter is the one who pulled the trigger. So let me get over to this. All right. So what I want to do now is go into the hearing that recently occurred. Okay. So let me pull this down. Okay. Okay, close that down, pull that off. All right. Okay, I have this video lined up. All right. Okay, that's not it. All right. Bear with me, kids. I will find it. I will find it. Okay, I think it's not. All right. Okay, I think this is going to be it right here. All right. So I want to get this up. I get it. Starting at the beginning. All right. So this is going to be a hearing that we're going to watch that took place, I think, within the last 10 days. All right. So let me stop sharing that and pull this up. All right. And this is starting Monday. All right. So I'm assuming they're going to pick the jury. I don't anticipate that picking the jury on this will take days. Hopefully they'll be able to pick a quick jury and get this thing rolling. All right. So let's see what we got here.
Is there any specific order that the parties would like to proceed?
Judge, if we could start with the state's motion only as to the delay in charging.
You guys hear that?
All right, we'll just proceed in the order listed on the notice of hearing. So number one for the state is a motion in limine as to delay in charging the defendant and decision not to charge all the defendants. Please proceed.
Thank you, Your Honor. Primarily, I'm going to rely on my motion. I'm sure the court has read it.
All right, hold on. Let me mess with it. Let me pull it. I gotta shrink it. All right, I'm gonna turn on the booster. Crank it up. It might crank me up too, so you guys watch your ears. Watch your ears. Okay.
But there's no question that there are states are going to be mentioned. The jury is going to know that the remains were found in 2018, and the charging decision based on the date of the information is after that. The focus of the state's motion is to prevent the defense from arguing to the jury or trying to elicit through any detective or witness the reason behind the delay in charging. That information is exclusively within the purview of the state attorney's office and the prosecutor's office. The state has exclusive authority to determine how to charge, who to charge, when to charge. That all lies in our inherent statutory authority. To interject any suggestion of the reason why the defendant was not charged immediately interjects completely irrelevant evidence. It would then introduce a need or requirement for the state to possibly call the prosecutors involved in this case to explain what was going on, when we received information, why we made decisions that we did, all of which are again within the purview of the state attorney's office and not relevant. If that evidence were to be admitted or allowed to be argued, that would in essence put myself, Mr. Camuccio, potentially now Judge Emily Harrington, because she was involved in this case at some point, into the witness list of having to testify and explain those decisions, potential changes in the law which could impact the decision to file, and none of which is at all relevant as far as whether or not Ms. Shaver committed these crimes. For the remainder of my argument, we're relying on motion.
All right, Mr. Wiggs,
Yeah.
have any objections to the board?
Judge, I don't agree with that. We wouldn't concur in that. The jury.
All right. Is the volume a little better? I see a couple saying can't really hear. Kavlaw. I've got the booster almost all the way up. So I don't know if I'm super loud right now, but I've got the booster way, way up. Let me know what you guys think. I could try to find another stream of it, but I mean, I think Court TV was. Yeah, Cav, you might want to put headphones on.
Is instructed that the state has power in the investigative process, but the manner in which the case is investigated, the time in which it's investigated, the manner in which it's investigated speaks to the weight of the evidence, the credibility of the evidence in this case, which is fair comment by the defense. To just say, you can't talk about these things, we got providence in this area, it invades the defendant's right to argue the merits of the state's case. Obviously, if the evidence was overwhelming at the very outset, Ms. Shaver would have been charged. So it goes to the weight of the argument that we're able to persuade the jury. It doesn't deal with the powers of the state. You're just invading providence and the privileges of the defense and making fair comment at trial.
All right, Mr. Buxman?
I think Mr. Wiggs may have misunderstood the purpose of my motion and my argument. Clearly, the manner of investigation is relevant. My motion was limited and focused solely on preventing the defense from getting up and arguing It took the state X number of years to charge the defendant, therefore they must even believe she's not guilty, or something to that effect. Of the questioning or implications of the state's reasons for the delay in charging, not the investigation.
No, I understand it quite clearly. The state's just saying, if you want to deal with time, you can't talk about it. Okay? No, we want to be able to talk about it as to how this.
Relates to the state's charging decision, is that correct, Mr. Buxton?
No, not to the charging decision, as to the time. The state has spoken that as to exclude, I think the time it took for them to investigate the case and make the final decision. And the state was saying, well, that would cause us to have to call, for me to have to take the stand, et cetera, et cetera. Well, the evidence is presented to the state at some point. But what law enforcement did, how they investigated it, how long it took them to investigate it, and then deliver it to the state, and how long it took the state to make decisions, those are all fair argument for the defense. The jury, as part of the instructions, is instructed to rely on your common sense and reaching their verdict. That goes to how the manner of the case was investigated, put together, and how much time it took them to reach the decisions that ultimately Laurie Shavers sits here on this information. So those should not be barred from comment, Judge.
All right, anything further?
No.
For the limited purpose requested by the state, the motion in limine is granted.
And to what extent, Judge?
Regarding the state's filing decision and timeline that the state took.
Okay.
Now, law enforcement investigating the case and how long that took it is a separate issue.
Okay, so we can discuss how long it took law enforcement to investigate. Okay.
So essentially what they're arguing about there is that the state had filed a motion in limine, anticipating that the defense was going to be using the fact that it took the state seemingly a long period of time after Michael was discovered to charge Laurie with the crime as an indication that the state does not really believe that it has a strong case against her. And obviously the judge was like, well, no, I'm not going to let you do that. However, I will allow you to question the cops about their investigation and how that went and the length of time that took. So I think it's the right ruling by the judge. It's kind of it's definitely a more prejudicial than probative argument by the defense. And frankly, I don't know how they would have, I'm assuming that he would have just flat out asked the question, it took you so long to charge my client because you didn't believe you had a strong case, right? Something to that effect. So the judge has basically said, can't do that, but I'll let you question him on other aspects of the investigation.
All right, move on to number 2. State's second motion is the motion to strike defendant's notice of intent to rely on business records.
One second, Judge, I'm sorry.
Let me know when you're ready.
Okay. The next one is what that we're taking up?
Next one on the notice is motion to strike defendant's notice of intent to rely on business records.
Nick Ruccio, I'll be arguing this issue.
Yes, sir.
We have had a similar hearing on these specific documents already as it related to Mr. Wiggs's attempts to have the court take judicial notice of the contents of the domestic relations injunction, as well as the state's law enforcement report from the 2014 domestic violence case that they have referenced at various points. I had also filed, because they filed notice of intent to allow business records certifications to try to get those documents in. I filed motions to strike that because the reports themselves just are not admissible in that fashion. I've supplied a subsequent memorandum of law that specifically references police reports and DCF reports and how the tool of notice of intent to allow business record certification is improper to get all of that information in, as it is filled with various hearsay and inadmissible evidence. As I stated at the hearing involving their attempts to get this evidence in through judicial notice, I am not saying that they cannot bring up issues of the injunction or the domestic violence arrest from 2014. However, simply putting in reports that are filled with nothing but hearsay is not the way to properly admit that evidence before the court. So I filed the motion to strike the notice of intent to allow business record certifications, as that is not a proper vehicle to admit reports. Throughout the proceedings of this case, Mr. Wiggs has marked various reports and portions of reports as exhibits for purposes of hearing, and I have repeatedly talked at those times about how that would not be appropriate exhibits for trial, but for purposes of those hearings, it was permissible. I am also aware that Mr. Wiggs has attempted to just mark reports and depositions in trials in front of this court, and as attempts to just wholesale put those exhibits in, which is improper. So my memorandum of law, as well as my motion, fully outlines all of the arguments, but that is what the basis of this is.
All right, thank you, Mr. Wiggs.
Please, Judge, with regards to this, I thought the court has already ruled on this matter as to the arrest of Michael Shaver and spoken about this and ruled on it at this stage. So I don't know if Mr. Camuccio is asking the court to rule on something that's previously been ruled on at this stage. That I'm not certain. I understand that there's a predicate that has to be laid for the introduction of evidence. I'm aware of that, but I believe you've already ruled with regards to Michael Shaver's conviction and the domestic violence issues at this stage. We haven't moved at this stage to seek to introduce any evidence at this stage, but I believe you've already ruled on it, Judge.
Well, Mr. Camuccio, do you want to differentiate between what was ruled on previously and what you're seeking now?
Yes. The previous hearing that we had was the hearing that we dealt with that was titled, Mr. Wiggs titled Reverse Williams Rule. And there was a request for judicial notice of various items in the court file, including the injunction, as well as the police reports. And the court had ruled already that those documents could not come into evidence through through judicial notice. We have repeatedly said if witnesses that were actually involved in these incidents were to come forward and state this is what happened, that is the correct way of putting this evidence in before the jury, not just putting in a police report and having that be, as a matter of fact, what happened on that night. This particular filing is because not only were they requesting the court take judicial notice of those documents, they filed notices of intent to rely on business record certification to move in the records from 2014 DR 1502 and 2014 MM 5308. So this motion specifically is saying that they should not be allowed to put in those records as business record certifications based on their notice. And the statute specifically says that if a party files the notice of intent to rely on business record certification, if opposing party has an objection to that, it has to be done before the trial, so that if generally the procedure would be, so if there is an issue with the notice itself, if the party wants to bring in the live witness that would be the business record custodian, they could do so that way, as opposed to finding out in the middle of trial that opposing counsel had
All right. First of all, Don Burke, $10 holla. Thank you so much. After a heavy week, you said train station. Were you talking about the train station on Yellowstone? You mean where Rip brings? Now remember, we can't talk about Yellowstone when Jay's on because he hates it. I loved the first 2 seasons and I thought it jumped the shark. But Rip, one of the main characters, when he's bringing you to the train station, you never come home. All right, so I want you to raise your hands. We've kind of dove into the last step before trial. Show of hands, who wants me to read through the affidavit first, which lays out a lot more of the factual scenarios behind the state's case. All right. Like just do the little hand thing like Dizzy did. If I see enough of them, it's going to be reading time. It's medication time. It's time to read. All right. Let's see. All right. Dizzy's the only one who's okay. Got Sinead. She raised her hand. Dizzy. So 2. Simply Bell. Yeah, the daughters is not going to be brought in. Dizzy also sent me the motion about the daughter and not being able to get into that. So I'm not exactly sure in light of the fact that they're not going to be able to lean on that for the defense. I don't know if they're just going to argue it's a circumstantial case. Somehow her husband was buried on the property and then someone laid a concrete slab over where he just happened to be buried. I guess that's the defense, I guess. All right. Okay. I've seen enough hands. I'm going to pause that and I am going to pull up the affidavit. We will read through that quickly. It's a little lengthy, but I think affidavits are important. You guys know I like reading. Reading's important. All right. Okay. Let's pull this bad boy up. So this is the affidavit of probable cause. All right. So again, they give that time frame of November 7th through the 10th of 2015. That they believe that Laurie Shaver did commit homicide of the second degree and is an accessory after the fact to homicide in the second degree. And these are the facts that they are putting forward that they believe supports probable cause in order to make the arrest. So that the events hereinafter set forth occurred at 9850 Sandy Pines Road, Claremont, Florida, in Lake County. This property was owned exclusively by victim Michael Douglas Shaver and defendant Laurie Lee Shaver, husband and wife. The events occurred between November 7th and the 10th of 2015, during which time the only adults that lived in the home were Michael and Laurie Shaver. And during this time frame, Laurie Shaver also worked from home. So deputies responded to the Shaver home for a well-being check on victim Michael Shaver on February 16th of 2018. So we're talking, 2 years and change. I mean, that's a long time. And this was at the request of a friend, Scott Amatuccio, who reported that no one had seen Michael Shaver since the end of 2015. Mr. Amatuccio felt that the totality of the circumstances surrounding Michael Shaver's disappearance were suspicious and that his wife, Laurie Shaver, wasn't being truthful about his whereabouts. Laurie vaguely claimed that Michael left in a black SUV, yet Scott knew his possessions still to be at the home afterwards. Scott found the text messages to Michael's boss quitting his job and giving away his tools to be very unlike him. Scott believed Laurie was pretending to be Michael on his Facebook. Scott also thought that the concrete slab fire pit that appeared on the property after Michael's disappearance, along with Laurie quickly remarrying, was suspicious. Scott consulted with Michael's family, who also agreed that he would never leave his kids to start a new family, as Laurie claimed he had. and the decision was made for Scott to contact authorities and report Michael missing. While investigating the well-being check, defendant Laurie Shaver told deputies that Michael left the family and was in Georgia. She said the last time Michael was at their house was when he picked up his belongings after his arrest for domestic violence in September of 2014. And the last time that she saw him was during a DCF custody trial in 2015. Laurie was cooperative and allowed the deputies to search the property until they had asked about the concrete slab fire pit and if they could have a cadaver dog conduct a sniff of the slab. Laurie then told deputies, "Leave my property. Leave. You must go." Detectives subsequently learned that Michael had no current cell phone and his Florida driver's license, U.S. passport, and FAA pilot's medical certificate had all expired. By the way, Michael was a pilot and then at some point became a mechanical engineer, I think over at Epcot, working on the monorail. Okay, so he had no driver's license in any other state. His vehicle had been repossessed in February of 2016, and court paperwork for a civil lawsuit for non-payment of a credit card had gone unserved on him because he was unable to be located. Every acquaintance of Michael who was contacted advised that they hadn't seen him since the end of 2015. So Michael Shaver was entered into NCIC as a missing person, and the investigation into his disappearance began. During the missing person investigation, Travis Filmer, Laurie Shaver's boyfriend, who she began dating in approximately January through April of 2016, told deputies that Laurie made the statement about Michael Shaver that, quote, "It's not that he's missing. He's no longer walking this earth," end quote. Laurie also told him regarding Michael that something bad had happened and that there was a body on the property. Oops. On March 9th, 2018, deputies served a search warrant for cadaver dog and ground penetrating radar at 9850 Sandy Pines Road in Claremont, the Shaver property. During the search, the skeletal remains of Michael Shaver were unearthed from 3 feet beneath the concrete slab/fire pit. Michael Shaver was clothed in socks, shorts, and underwear. Also removed from the body was a tarp, a set of ratchet straps, and the remains of a fitted sheet. The tags indicated the sheet was queen size and purchased at Kohl's, a department store frequented by Laurie Shaver, as proven by her bank records. The remains were confirmed to be those of Michael Shaver by DNA. Michael Shaver's cause and manner of death is homicide by gunshot wound in the back of the head, with a posterior to anterior trajectory, back to front. A single .38 caliber class projectile was recovered from Mr. Shaver's skull. Time of death was determined to be several months to several years prior to discovery. During a second search warrant served on the Shaver home, Blue Star, which yields a presumptive detection of bloodstains hidden from the naked eye, indicated a positive reaction in the track of the sliding glass door leading from the dining area to the porch. The substance ran in a drip-like pattern down the outside of the trailer between the home and the porch. The substance, along with apparent hairs found in the same area, failed to demonstrate a sufficient amount of DNA for an STR DNA analysis. Swabs from the interior lower track of the sliding door demonstrated the presence of a mixture of DNA consistent with 3 donors, including Laurie Shaver and 2 unrelated individuals, at least one of which is a male contributor. Michael Shaver could not be included or excluded as a contributor, which happens many times with mixed samples where you have multiple contributors. It is believed that Michael Shaver was killed between November 7th of 2015, the last day he was seen, and November 10th, 2015, the first day he did not show up to work. Investigation revealed that Michael Shaver's cell phone was last used to make an outgoing call on November 7th, 2015 at 5:48 p.m. Michael was also last seen in public with Laurie Shaver and their 2 children on November 7th of 2015 by coworker Frank Merritt. Frank Merritt attended a tractor show with his wife and the Shavers and stated that Michael and Laurie did not appeared to be getting along and left the event early to go home. Mr. Merritt texted Michael the next day, November 8th, and got no response. Mr. Merritt texted Michael on November 9th and received a response that he was quitting work to save his marriage. Michael did not report to work or call in on his next scheduled workday, November 10th, and was never seen again. Michael's boss, John Borglum, advised Michael was a reliable employee in line to become a foreman and never missed work without calling in. November 11th, Laurie sent a private message via a work server to Alicia Ray, her sister, stating, quote, "Mike left yesterday, packed his stuff and went to the airport," end quote. On approximately November 12th, John Borglum texted Michael and received the response, quote, "I'm having issues at home in Georgia right now. Just fire me or I'll quit. I will not be returning anytime soon," end quote. Frank Merritt went to the Shaver home on November 13th to check on him. Laurie told him that Michael left and went to Georgia after they got into a fight about another woman's number being in his phone. Frank asked Laurie how Michael had gotten to Georgia since his vehicle was still at the Shaver home. Laurie then claimed a friend, Robert Mercado, had picked Michael up and driven him to Georgia. Robert Mercado, when interviewed, denied ever driving Michael to Georgia. On Monday, November 16th, Laurie sent a private message via work server to Alicia Ray, talking about her weekend, which would have been November 14th to 15th, and told Alicia that she did, quote, "tons of yard work," end quote, and cleaned up outside. So that's when the slab went down, right? November 16th, I think. Beginning on November 9th of 2015, or no, that was all the way the following year. So that must have been the burying. So beginning November 9th, 2015, friends and families of Michael Shaver, to include Robert Mercado, Frank Merritt, and his boss, John Borglum, received texts and Facebook messages from Michael. These texts and messages were, quote, "unlike Michael," end quote, in tone. For example, telling his boss to go ahead and fire him because he wouldn't be coming back to work, telling his boss and Frank Merritt to keep his personal tools because he wouldn't be picking them up from work, telling Robert Mercado to, quote, "leave me alone and don't bother me," end quote, when Robert was planning on spending Thanksgiving with the Shavers. In January of 2016, Christine Quarty, Michael's sister, received a Facebook message reply after reaching out to Michael that read in part, quote, "everyone just needs to leave me alone, just like they did my entire life," end quote. In September of 2016, Desiree Snyder, Michael's niece, sent a Facebook message to Michael and received the reply, "who are you?" Then, quote, "I don't have any family anymore. I have no clue who you are. Now stop messaging me," end quote. Michael's family points out that Laurie would not have recognized Desiree's maiden name. However, Michael obviously would. After November 9th of 2015, Michael Shaver's debit card is never used again for any in-person or in-store purchases. On November 19th and again on the 23rd of 2015, two separate online purchases were made at wish.com using his debit card. It is confirmed through wish.com that these purchases consisted of female lingerie and clothing items that were both shipped to Laurie Shaver at the Shaver residence at 9850 Sandy Pines Road in Claremont, with a confirmation email address of redacted. On November 30th of 2015, a check for $2,539 was mailed from Mariner Finance in Leesburg, Florida, to Michael Shaver at his home address. On December 11th, 2015, the back of the check was endorsed with an unreadable signature, Michael Shaver's social security number and cell phone number, accepting the terms of the loan. On December 14th of 2015, the check was deposited into Michael Shaver's Chase checking account via an ATM in Claremont. Between December 14th and the 30th of December 2015, multiple ATM cash withdrawals were made from the account, along with online purchases and one payment to Sumter Electric Power Company, the power company used at the Shaver home. On December 15th, 2015, an online purchase was made at Walmart.com from this account for $424.54. The receipt for this order shows it was for children's items and was shipped to Laurie Shaver at the home address of 9850 Sandy Pines in Claremont. The withdrawals and purchases totaled over $2,000 and caused Michael Shaver's account to be overdrawn by December 30th, 2015. After a few more purchases and fees, the checking account remained overdrawn and was never used again. Prior to November 9th, Michael Shaver used his checking account almost exclusively by making debit purchases in person at stores. Afterwards, the purchases were online and ATM. All in Claremont or shipped to the Shaver residence, not Georgia, where Laurie had said that Michael was located. According to Mariner Finance, no payments were ever made on the loan, and they never spoke to or saw Michael Shaver. All attempts by Mariner Finance to contact Michael Shaver to collect on the loan for the next 3 years met with negative results. Investigation has revealed no indication that any adult other than Laurie Shaver lived at the Shaver home, where the Mariner Finance check and 3 internet orders were mailed to her name during the November through December 2015 timeframe. The person who made the deposit and withdrawals would need to have the ability to intercept Michael Shaver's mail from his secure community mailbox, have access to his social security number, his ATM card for 2 weeks, his PIN number, and have the knowledge that Michael Shaver would not be around to notice the fraudulent deposit, the multiple withdrawals, or packages being shipped to his residence. By the beginning of December of 2015, Laurie Shaver was selling and attempting to sell Michael Shaver's firearms, tools with which he made his living, vehicle, home, and property, and other possessions. Joseph Bray, owner of JB Guns in Bushnell, Florida, overheard her attempting to sell multiple guns and selling one gun to the owner of Outrageous Audio in Mineola, Florida, on approximately 12/5/15. Mr. Bray offered to purchase the remaining firearms and responded to Laurie Shaver's home on approximately December 6th or 7th of 2015 to meet with her and make the purchase. There, he purchased 9 firearms, including 2 .38 caliber revolvers, reload equipment, and a firearm cleaning supply for $1,000 from Laurie Shaver. Laurie was alone at her home and told Mr. Bray the firearms had belonged to her husband, that he had left, and she hadn't seen or heard from him and didn't know where he was. I mean, this thing is like it's got that kind of like Tellus vibe with Laurie was alone at her home, and she told Mr. Bray that I read that already. So she considered the items hers now, and she was going to sell them. Mr. Bray thinks that she said that her husband had been gone a couple of months. Laurie told Mr. Bray that her husband was an aircraft mechanic and that she had sold his aircraft mechanic tools the previous day for $1,000. Laurie offered to sell Mr. Bray her husband's Ford vehicle, which was in the yard without the title, and offered to sell his tractor. She also said the house and property were for sale for $150,000. Mr. Bray thought it was unusual that a man would leave all his possessions behind, including several firearms and expensive work tools. In March of 2018, when Mr. Bray saw Laurie Shaver and the Shaver property on the news, he recognized Laurie as the woman he purchased the firearms from and recognized the property in the trailer as the location he had met Laurie Shaver as to purchase firearms from her. From November 7th until 2015, until Michael's body was discovered, Laurie Shaver continued to tell friends and family that she saw and spoke to Michael Shaver and that he was stalking her. On December 3rd of 2015, she sent a private message to his supervisor, Ramin, and I'm not going to even try to pronounce that last name. It looks to be 2 letters shy of the alphabet, through a work server, claiming that she had been getting child support, but now Michael was in jail for non-payment after losing his job. Laurie, at different times, claimed Michael was in Georgia, New York, and California. She said Michael left her and the kids to start a new life. Laurie told her boyfriend, Travis Filmer, that she was divorced and, quote, married him, even though her marriage to Michael was still valid. When questioned by her sister-in-law, Rebecca Urbanowski, about her divorce, she stated it was final and that Michael was at the courthouse with her for the hearing in a separate room. She told Travis's mother, Kendall Windsor, that Michael was a pilot, which is why he was never around. Laurie told her best friend, Katina Vasquez, in 2017 about an incident where Michael had followed her and she had to pull over and allow law enforcement to search her truck and cell phone for 2 weeks looking for trackers installed by Michael. Laurie told Katina that it was the Lake County Sheriff's Office in Claremont that had her truck and cell phone for 2 weeks. Though Laurie told friends that she was being stalked by Michael, no record had been found of her ever reporting any of these incidents to law enforcement. Laurie never attempted to file for child support from Michael for their 2 children. Laurie never reported Michael missing. There is a $208.90 charge on Michael's Capital One credit card a few weeks after his disappearance on 11/30/15 at mydivorcepapers.com. However, there is no record that either Michael nor Laurie ever filed for a divorce. No person other than Laurie Shaver ever saw or verbally spoke to Michael Shaver at any point from November 7th, 2015 onward, to include his parents, siblings, friends, neighbors, and coworkers. Investigation revealed no indication that Michael existed anywhere after November 7th, 2015. Laurie Shaver informed Michael's boss to dispose of his tools at work. She also sold some of Michael's possessions in the months after his disappearance. Laurie allowed Michael's car to be repossessed from the property by February of 2016 after her attempts to sell it with no title failed. Laurie never called Michael's cell phone after November 3rd of 2015. Prior to that, she called him multiple times per week. It is believed the fire pit was constructed in March of 2016 and the concrete slab was poured in September of 2016 at a location on the 5-acre property chosen by Laurie with her and Travis's initials over the area of Michael's body. Oh, this chick is warped. Two photos and a post to Laurie Shaver's Facebook page dated 3/24/16 show the fire pit being built along with the statement in part, quote, newest project, built this fire pit today and now just need to pour in concrete, end quote. A photo and a post to Laurie Shaver's Facebook page dated 4/28/16 shows bag of concrete mix, at least 14 visible in the photograph, stacked in the back of a pickup truck. A comment by Lori Lee Filmer states, quote, cement, it's going in the area around the fire pit I built, end quote. The concrete slab was poured over Michael's grave, is known through a witness statement, Rebecca Urbanowski, Lori's sister-in-law, to have been poured by Lori and her boyfriend, Travis Filmer, in the, quote, summer of 2016. Travis Filmer told detectives that he and Lori rented a cement mixer from the Home Depot for the project. Laurie Shaver and Travis Filmer, their joint bank account records, SunTrust checking, show a $290.05 purchase at Lowe's that posted on 9/13/16, which was confirmed through receipts to include 42 bags of concrete mix. The same bank account shows a charge of $75 at the Home Depot, which was confirmed through receipts to be for the rental of a large electric cement mixer on 9/12/16. The cement mixer was rented by Travis Filmer. Travis's name, address, and the last 4 numbers of his Florida's driver's license are recorded on the rental receipt. Filmer told detectives the hole, when he saw it in 2016, was only 3 to 4 feet deep. When they filled it with concrete, he thought it was odd that the dirt pile on the edge of the property, Laurie said that they came from the hole was much too large to have come from. That's 3 or 4 inches. 3 or 4. Isn't foot like 1? Like just 1, not the double? To have come from a hole only 3 to 4 inches deep. I'm pretty sure. Isn't that inches? Somebody confirm that. Isn't it like the quotation mark, like inches? I thought 1 was foot, 2 was inches. A photograph on Laurie Shaver's, yes, Bob, thank you, Dizzy. A photograph on Laurie Shaver's Facebook page dated 2/27/17 shows the concrete slab in place. The presence of the concrete slab is confirmed by Google Earth satellite imagery by March of 2017, though Laurie continued to report seeing and speaking with Michael after this date. For several months after Michael's disappearance, friends, family received text messages from his cell phone and private messages from his Facebook account. A friend, Katina Vasquez, told detectives she saw what she believed to be Michael's cell phone, along with his clothing and other personal belongings inside the Shaver home not long after his disappearance in November of 2015, 3 days after Michael's body was discovered. But prior to being positively identified by DNA, a postcard with his photograph was mailed from Orlando to Laurie with a handwritten message. Quote, "Tell the kids I love them. See you soon, Mike." End quote. Michael's Facebook page was updated more than once, and as late as January 2nd of 2018, often utilizing the same IP address as Laurie Shavers' Facebook page updates. This chick's an idiot. Jesus, what a terrible, terrible criminal. 15. Jeremy Townsend was interviewed and said he began dating Laurie Shavers. What happened to Travis? Travis is gone. Travis, old Travis Filmer. Travis is out of the picture, I guess, at some point. Oh no, this is before Travis. Jeremy Townsend was interviewed and stated he began dating Laurie Shaver in approximately September of 2015. So I stand corrected. He's pre-Travis, after she told him that she left her husband. The first time that Jeremy came to Laurie's home in approximately December, he noticed that he thought was blood stains on the thigh of her jeans. He asked her if that was blood on her jeans. Is that blood on your jeans? Laurie changed the jeans and never wore them again. Jeremy remarked that prior to that, Laurie wore those jeans 3 times a week, but he never saw them again. She loved those jeans. Always wearing those. She wore them all the time, 3 times a week. Beginning in February of 2016, for several months, Jeremy Townsend's wife, Vanessa, received Facebook messages from Michael Shaver's account. What? So wait, she was now she's texting Jeremy's wife via Michael Shaver's account. Okay, and then text messages from someone claiming to be Michael. The Facebook messages went unread until April when she received a flower delivery at work with the message, quote, "Roses are red, violets are blue. My wife is a whore. Your husband is too. Sorry about this. Check your Facebook message. We need to talk. Mike." Wow, end quote. Mike Shaver told Vanessa Townsend via Facebook Messenger and cell phone text that he installed a spy app on Laurie's cell phone and captured text messages and explicit photographs sent between their spouses, which, quote, he, quote, end quote, shared with Vanessa. These messages and photographs were solely intended to notify Vanessa of the affair between Jeremy and Laurie to encourage Vanessa to leave Jeremy. At one point, when Vanessa spoke about staying with Jeremy, quote, Mike, end quote, insinuated that he thought that Laurie might have been pregnant by Jeremy. Mike also gave, they keep putting Mike in quotes because obviously it's Laurie. Mike also gave Vanessa the name of a good divorce attorney. Vanessa confronted Jeremy with the evidence of the affair, which he admitted. In April of 2016, Jeremy broke off the affair with Laurie and repaired his relationship with his wife. Jeremy also described a tattoo Laurie got of his nickname, Jay, in a heart over her vagina. Wow. Which caused him to think that Laurie felt more serious about their relationship than he did, which he always considered purely sexual. Mr. and Mrs. Townsend are cooperative with the investigation and provided the card and envelope from the flower delivery, along with 600 pages of text messages, Facebook messages, and photographs between Mike Shaver and Vanessa Townsend, all which began 3 months after Michael's disappearance. The messages show that between 2/23 of 16 and 2/26 of 16, Laurie confronted Jeremy via text, asking why he's wearing his wedding ring again, accusing him of lying to her about his whereabouts, not moving forward with his divorce, and asking if he was, quote, in love with her, presumably referring to his wife. The first time Mike Shaver contacted Vanessa Townsend to speak to her about their spouse's affair was on 2/25 of 2016, during the time frame of this argument between Laurie and Jeremy. The same Facebook messages have also been recovered from Facebook Inc. pursuant to a search warrant. The cell phone number used by Mike Shaver to text Vanessa Townsend from 4/11/16 until 4/21 of 16 is not Michael's known cell phone number, but rather a number that was only active from 4/6 until 4/16, of which the sole subscriber was Laurie Shaver. She's not a good criminal. The flower arrangement sent to Vanessa Townsend from Mike in April of 2016 was purchased on Laurie Shaver's BB&T checking account from You Flowers, posted on 4/7/16 for $42.98. Sorry to laugh. This is not a laughing matter, but Jesus fucking Christ, this woman. The invoice for the flowers shows Mike Shaver's name along with the exact message and purchase amount of $42.98. Order confirmation shows the order was delivered to Vanessa Townsend at her work address on 4/11 of 2016 and signed for by Mrs. Townsend. A confirmation email would have been sent to the email address provided, redacted, right after the order was placed, 4/5/16 at 0:35 or 03:53 hours, and right after the order was delivered, 4/11/16 at 14:39 hours. One of the early Facebook messages from Mike Shaver to Vanessa Townsend was sent on 4/11 of 2016 at 03:18, the day that the flowers have been delivered at 1100, and states, quote, "Your special delivery is to arrive today. Hope to finally hear back from you." Flower arrangement emoji, end quote, indicating the person who was sending the messages to Vanessa on the Mike Shaver Facebook page is the same person who used Laurie Shaver's bank account to purchase and send flowers to Vanessa Townsend. Review and comparison of the IP address listed in Facebook activity logs for the Facebook accounts associated with Michael Shaver and Laurie Shavers. So 13 IP addresses that are identical on both accounts, indicating the devices used for Facebook activity on both accounts were on the same network. A friend of the Shavers, Mary Lewinberg, Lewinberg, showed detectives a text message between herself and Michael that read, "Michael, she wants my life insurance," and that's in quotes, referring to Laurie Shaver. Mary, quote, "She's got to kill you first," end quote. Michael, "Yeah, she tried yesterday, I'm sure," end quote. Mary was unable to remember the exact date of the text due to it being saved on an old phone, but stated that it was 2014 or 2015. She further advised Michael told her that Laurie would take over his means of communication, for example, pretend to be him on Facebook and text messages. Corey Lutzo, a coworker of Michael's, reported that Michael came to work approximately 3 to 4 months prior to his disappearance with several bruises, face, chest, and arms. Michael stated that Laurie had gotten irate and blew up about something. Michael didn't say what, and began punching him with her closed fists. When asked why he didn't at least fight back to defend himself, Michael said that he didn't because it wasn't worth it. Corey worked with Michael for approximately 1 year and recalls one other story Michael told him, in which he said that Laurie got mad and threw something at him, missed, and the item went through the kitchen window. Kendall Davidowski dated Michael Shaver from approximately November 2014 until May of 2015. All right, so this is where that's adding up. I knew that I had read that, that they were separated and that they were seeing other people. The only question is, I don't know if they were still living in the same home. Kendall and Michael met at Disney, where they both worked. During this time frame, Michael lived in an airplane hangar. All right, so there we go. See, just read the affidavit to give us all the answers. Okay. During this time frame, Michael lived in an airplane hangar and was separated from Laurie, who was also dating someone. Kendall stated Laurie told Michael that he was not allowed to date anyone, although Laurie was. Kendall witnessed Laurie on the phone telling Michael that he would never see his kids again and would seem to use the children as a pawn to get what she wanted. During Kendall and Michael's brief relationship, Laurie Shaver constantly sent Facebook messages to Kendall, harassing her to leave Michael, threatening to expose Kendall to her family as a homewrecker, and personally insulting her. Laurie specifically mentioned the name of Kendall's grandmother. Laurie called Kendall's mother in another state at 3 a.m. asking for Kendall. In April of 2015, Laurie called Disney HR and filed a complaint on Kendall using photographs from Kendall's Facebook page. Laurie created 2 Facebook accounts, fake Facebook account pages, and sent friend request to Kendall. Kendall recalled that whenever Michael would stay at Kendall's home after work, he would go to the hangar first to make sure that Laurie wasn't following him. One time in approximately February or March of 2015, Michael called and told Caitlin to park in a different lot than usual for work because Laurie was on her way to Disney with a gun. Michael did not explain further, and they never spoke of the incident again. Kendall broke off her relationship with Michael in May of 2015. Yeah, she must have been like, dude, fuck that. Like, I'm out. Your wife, Cray. Kendall broke off her relationship with Michael in May of 2015 because of all the harassment from Laurie and the fear of losing her job, or worse, if she complained again. Kendall advised their breakup was amicable and that she had no relationship problems with Michael, only issues caused by Laurie. After hearing in November of 2015 from Corey Lutzo that no one could find Michael, Kendall sent him a Facebook message and noticed his Facebook said he was living in Afghanistan. Michael responded, I left. Kendall asked, what about his kids? And Michael never responded to her again. Wow, Laurie Shaver. Laurie Shaver was known to keep a pink 38 caliber handgun on her nightstand. They were getting divorced. Like they were on September 4th of 2015, what was the life insurance policy? On September 4th of 2014, she retrieved this revolver from her nightstand and used it during the domestic violence incident, in which she hit Michael in the head with the gun, causing a laceration. Michael was arrested for simple battery domestic. Laurie's handgun was taken into evidence and released to her on June 1st of 2015. Michael's handgun was taken and released to him on the same day. On New Year's Eve 2016, Rebecca Urbanowski stated that Laurie became upset on her, quote, wedding night with Travis Filmer, locked herself in her bedroom, and then pulled a gun and had to be talked down by a family member. Man, she's unhinged. In approximately October of 2017, Laurie sold a 38 caliber handgun to a neighbor, Robert Siha, who later turned it over to LCSO. This handgun has been forensically compared to the 38 caliber class projectile recovered from Michael Shaver's skull and was unable to be included or excluded as being the weapon that killed Mr. Shaver. Robert Mercado reported that in September of 2014, when he drove Michael home to gather his belongings after his arrest, Laurie became angry at Michael and threw a handgun at Michael. Frank Merritt advised LCSO that his 38 caliber revolver was in the possession of Michael Shaver during the November 2015 timeframe, as Michael was supposed to be rebluing the gun from Mr. Merritt. After Michael's disappearance, Laurie Shaver returned the gun to Mr. Merritt. Oh my God! Along with the two 38 caliber handguns that Mr. Shaver sold to Joseph Bray in 2015, she had access to four 38 caliber handguns during the time frame of Michael Shaver's homicide. Laurie Shaver was the last person to see Michael Shaver and the only other adult occupant of the property where his body was buried. Days after he was last seen, Laurie lied about Michael going to Georgia with a friend. Laurie Shaver constructed the fire pit and poured the concrete on her 5-acre property exactly over Michael's grave. Laurie lied to family and law enforcement about Michael's whereabouts and claimed to have seen and communicated with him well after his disappearance and after the concrete slab was poured over his body. Laurie gave away, sold, or attempted to sell many of Michael's belongings within a month of his disappearance. Laurie drained Michael's bank account within a month after his disappearance after making a fraudulent loan deposit in his name. Laurie had access to four 38 caliber handguns at the time of Michael's homicide. Laurie told her boyfriend, Michael wasn't missing, that he was no longer walking this earth and that there was a body on the property. Laurie claimed to have seen and talked to Michael and assumed his identity on Facebook, Facebook Messenger, and in text in order to convince family and friends that he was still alive, a ruse which did not benefit her in any way other than prolonging the discovery of the homicide. So there you go. There you go. Man. Yeah, diabolical, but like a massive idiot. Like, Jesus. Like, she doesn't know about IP addresses, and like she didn't think that somebody'd figure out that was her shit and it was all coming from the house using his bank account. I mean, wow. Like, she did not watch and read enough like murder mysteries, Discovery ID, Oxygen. She's just she was not yet, like, she got away for 3 years. It's crazy. It's crazy. I mean, it makes me wonder if like like there must have been some kind of separation of the family, right? Like 3 years. Like I don't hear from like a family member of mine for 3 years. I'm gonna be like, what? What? Where are you? What? Call me. Quit messaging me on Facebook and call me right now. Yeah, I mean, that part of it's weird. That part is definitely weird. All right, so you guys feel like you're have a better grip on what's going on here? I definitely do. It's primer for me too. Primer for me too. So I definitely feel sister said that they tried really hard to find him, but never reported him missing. That's what Dizzy says. It's crazy. I mean, huh? It's hard. Like, it's hard to wrap my mind around. It's like the family, like as they got older, must not have been very close. I mean, to like for 3 years to go by and you're buying some bullshit story that he's just left and started another family somewhere in Georgia or New York or California. Boy, I don't know. Yeah, I think so, Phil. It's bingo time. Like, you got all the stuff. You got fire pits, concrete slabs, Facebook messengers, pink 38 revolver, all kinds of goodies. All right, let's get back to this. Fire this thing back up. Yeah. Yeah, everybody put up their hand who wants to play some bingo. I'm always down for bingo. This time I'm not missing my card though. I missed the card on Telus. I slept. I was sleeping completely. That's all right because I was donating a prize. So like with my luck, I would have actually won. You know, when I'm trying to give away a prize, it would have been ridiculous. All right.
Objection to it. My objection is stated that these records are not admissible as business records certificate, as business records, so therefore the notice of intent to rely on the business record certification are invalid. And my motion talks about how not only is there hearsay, but whether or not the clerk's office is actually the party that actually creates these records and maintains these records. They're not, they just take what is given to them and puts it in court files. So therefore they are not actually producing any of these business records, any of these records that he claims are business records. So yes, we have had a hearing. Yes, there has been determinations that certain areas of the injunction and the county court case are going to be admissible, but not simply by putting in police reports, domestic violence injunction petitions, and things of that nature.
Good. We didn't intend to do that, but I think if you look in your order, I think it's paragraph 16 and 17 is where you address it. And it states if you can lay a proper predicate. Okay. You'd already ruled on this. The state is just filing this late and now raising it a second time, but you've already ruled on it. You've stated, Judge, if you can lay a proper predicate.
Correct. And that was previously stated, but to the extent that Mr. Commiscio has cited or distinguished the prior ruling from the present request, the motion is granted.
Thank you, sir.
Okay, we'll move on to number 3. And state's third motion is notice of intent to agree to evidentiary summary and memorandum of law attached to it.
Yes, well, yes, Your Honor. This is simply dealing with the various IP records that have been that were compiled from the Facebook records themselves for the courts. So the court is aware the state is intending on admitting the Facebook records both from Michael Shaver and Laurie Shaver. We've had hearings on.
Yeah, I'm so glad we read the PCA because now this shit all makes way more sense, right? Now we know what Facebook messages are talking about. Got to fill in the gaps first. See, I always should have read the PCA. See, I let that one fan mail get in my head about the reading. Like, I'm a reader. I'm going to read. Always going to read. If people don't like the reading, you know what they can do. Always going to read.
The relevance of all of those already. It is my intent to put in the entire IP logs of both Laurie Shaver and Michael Shaver Facebook records, so the jury would have access to all of the information. The evidence summary that I've filed that is in compliance with Florida Statute 90.956 simply summarizes some of that information, and it is permissible tool to help assist the jury in understanding all of the records, but they will also have all of the records themselves, and they're fully able to go through and look and see that, yes, all these IP addresses and times and dates and numbers and all of that matches up. It is a summary as the rule allows to allow them to process pages and pages of information, but all of that information will actually be made available to them.
Mr. Wicks? Yes, ma'am, please, sir. Judge, we would contest to this and bring to the court's attention.
Yeah, I bet you're going to contest that. He definitely don't want those Facebook messages coming in, right, buddy? I mean, pretty damning.
I'm going to get the status summary. There's some private.
I cannot wait to see how they're going to try to defend this shit. Like, now that we know, yeah, like in Couch, the daughter pulling the trigger is out. Like, the judge apparently rejected that ridiculous bullshit, like, completely. So I don't think that that's coming in any capacity. So, man, I'm trying to figure out. I mean, this woman makes the Adelsons look like criminal masterminds. Like, and they're no criminal masterminds. Like, that shit was so sloppy. Like, that was her plan. Like, how much? I'm a little surprised that the affidavit, the PCA, did not include what the value of the life insurance policy was. Like, for a motive. Like, they're like on the way of divorcing. Like, they're split. Like, divorce. Get a divorce. Get a divorce. Don't kill your spouse. Just divorce them. This too shall pass. You'll survive it. It'll hurt. Be sad. It's way better than prison. It's way better than prison. And then you're not a murderer. It's way, way better.
Notes on the top that give the court a summary that deals with stacking inferences again. This goes back to stacking inferences.
Yeah.
We addressed this at a hearing, and it was our position that it was impermissible to stack inferences. The state was of the position that it's permissible to just throw everything before a jury, basically.
Oh, that's it. The state's just throwing everything in front of a jury. All this bullshit Facebook messages, like what? Just throw it all at them, and they're gonna. Wow, this is gonna be like this one, because this guy's not nearly. I could tell in the brief period of time that we've seen the back of his head that he is no Tellus's attorney. Like, Tellus's attorney was like, he had a steaming pile of caca there, and he did the best as he could. This guy, this is gonna be a ramrod right in the stink hole. That's what I predict for this.
That Bush had just done away with the concept of stacking inferences. So what the case I gave you deals with.
Oh no, what I was gonna say is I think that it's like a 7-year time period that of somebody being missing before they declare them dead. Like, sometimes you can get in, and get the courts to declare somebody dead. Like, but I think that was ultimately the game plan. Had to have been. She was gonna wait, say he was missing, say he fucked off somewhere and had a new family and abandoned everybody and everything he ever knew. And he had vanished off the face of the earth. And, she was hoping to collect the insurance money proceeds somewhere down the road. That's what I could think. Otherwise, why not divorce? Why? It's just murdery, I guess.
It's a statement of the law recently announced and the case cited. And that case is Smith versus Carlisle, 24 decision. And it goes back and it addresses.
Oh, that's awesome. That is awesome. I'm all about that. You just tell me how I can help you with that, Phil. I'm all about it. I'm on board. I'm here for it.
Addresses stack and inferences. And it goes through all the cases we discussed. It goes through Bush. It goes through Knight. It goes through Law, the cases that I relied on. But what it points out is really the state wasn't properly correct, and I wasn't entirely correct as well, what I'd represented before the court. What the case did.
Wait a second here, Susan. So our old neighbor ran off and abandoned his family. My parents thought the wife killed him. We believed that for years. Did he really run off and abandon his family? And just vanished? No one heard from him again? Ever? How do they confirm that he actually did that? Wow. I mean, I know it happens, just not in this case. I mean, it was, there's a lot of circumstantial evidence to show that that's not how it happened here.
It said, well, Bush did do away with the concept of stacking inferences. So you go back to the original case where this was addressed, which is Volcker versus Combined Insurance Company of America, 73 Southern 2nd 403, a Florida Supreme Court decision of 54. So that was reinstated by the elimination of Bush. And the court states this within it. The Supreme Court, stacking one inference upon another as a method of establishing an ultimate fact ordinarily should not be indulged in unless the first inference meets a test which may be analogized to the criminal rule concerning circumstantial evidence. And it proceeds.
I did, Megan. I haven't opened it yet. I was running around all day. I got back. I had to do the live, then I recorded, and then I ate. So it's sitting on my counter. I'm anxious to open your care package and see what kind of goodies are in there. That's so sweet. You're the first person to ever send me a care package. So that's amazing. Don't tell me what's in there. I want to be surprised. So yes, I did get it. And I will, of course, thank you once I open it. So yes, package received.
It's thereafter and says, only if the prior or basic inference is established to the exclusion of any other reasonable theory. So the decision declares that basically, yeah, you can stack inferences, but your initial inference that you're going to build on has to be subject to no other reasonable inference. So the state can go and proceed and say, we're going to just build it from there. Of course, then the jury is just told.
Okay, here's the base. Here's your base inference, buddy, that she shot him, killed him, and buried him on the property. That's the baseline inference. That's what they're going to stack on. I just want to be clear. Does this guy understand what I'm saying to him? So listen, that's the base. That's the base inference, that he was alive and then he wasn't. And then they found the body where she happened to lay a concrete slab that she posted on Facebook about. So the baseline inference, the base of the pyramid of inferences is going to be that he was alive. She shot him. She buried him, laid a concrete slab, then pretended that he was alive and well in some other state living with another family. So that's the baseline inference there, that he was alive and then she shot him.
Weigh the credibility of the evidence on their own. There's no special instruction anymore. So now to take their position now that they want to stack an inference go back to stacking inferences, what they've done is they've taken a summary. And the court has said, yeah, okay, you can use these records. But Judge, they still, just as Mr. Camuccio just stated in the last motion, he said, you still have to lay a proper predicate, Mr. Wiggs. And I said, yeah, I know that. And that's what the judge ordered previously. So you can't take a summary when the facts are of dispute, which they are, okay? Digest a bunch of facts into a summary, put it before a jury and say, accept our version of these facts. Okay, that's what we want you to use. That would run afoul to the case that I cited before the court previously, which is the Supreme Court decision, Yisrael, and the motion for to exclude the digital data that I cited. That case, you'll recall, Judge, was a case wherein the state prepared a document through the Department of Corrections as to the release date of the defendant, and then tried to move it in as a business record for purposes of habitualizing them. They said, no, that wasn't a business record. You generated it after the fact, as they do here, to summarize facts and put it before the jury and say, this is our version. You have to accept this version of the evidence. Well, what they're doing is trying to establish a predicate. The state acknowledges they still got to establish a predicate. Now, in the motion for digital data to exclude it, I set forth, I think, 4 different predicates that have been recognized in this state, and that was through the case, I think, Walker versus Anderson, that's cited in the memorandum. And all of them establish one common theme, as I announced to the court, that there has to be a tight connection in multiple manners between the facts and the defendant, excluding all other reasonable probabilities and possibilities. So to just sit there and summarize some fact, put it before a jury and say, these are all clearly discernible from the evidence that we're going to introduce, disregard anything Mr. Wiggs has to say or any expert or anybody else he has to offer you, and accept this and then tell the court we've established a predicate, that's impermissible. You're generating facts after the fact, trying to use it as a business record, and then establish a predicate at the same time. That's only proper when the facts are not subject to dispute between the parties, that you can admit a summary in that manner. So we'd object to it on those grounds.
Then don't submit the summary.
The
Submit all.
defense likewise would point out to the court that proceeding in the manner that the state would suggest would preclude the defense from being able to examine each witness as they dealt with the evidence, the digital data, how they got it, what they did with it, how it came to it, and would deprive the defense of a right of confrontation and cross-examination.
Oh, I did. I got a wonderful $20 Venmo from Michelle J. $20 for a bag of cough drops after reading much pages. Please keep reading. Thank you so much. I appreciate it. I'll always keep reading, but I will definitely get the cough drops too. I was starting to crack. I was starting to crack a little, and I ran out of drink.
Examination under the law. So I advise the court, Judge, that one, the state can stack some inferences to try to reach that predicate, but one, the standard is a higher standard than the state may assume it is. And on these grounds, we'd ask that the state's motion at this stage be denied.
Mr. Commissioner, do you wish to respond?
Couple things. First of all, none of the stuff that Mr. Wiggs is arguing has anything to do with what this motion is requesting. It is saying that these records, which have been determined in a pretrial ruling, are relevant, that we are taking the data from them and compiling them into a chart. That's all this motion is saying. What he is talking about deals with potential JOA arguments.
Oh, I can't take credit for this one, Squeegee. This is all Dizzy. Dizzy's like, Bob, are you going to do Shaver? I'm like, is that the one with the woman who killed her husband, buried him on the property? They didn't find him for years. And then she blamed the 7-year-old. She's like, yep. I'm like, I don't know. And then I started thinking about it. I was like, yep. So no, that was all Dizzy. Dizzy gets full credit there. Per usual.
When he starts talking about the stacking of inferences, this request simply talks about compiling data that will be in front of the jury and putting it into a chart. That's it. Mr. Wicks, please don't interrupt me.
I'm sorry, counsel. You don't need to get upset.
Oh, Snippy.
The other thing is this is not the first time we have been presented with, quote,
I predict that everyone, including me, is going to hate Attorney Wiggs by the end of this trial. Not this guy, the other guy, her lawyer, Mr. Wiggs.
case law without any.
Are we going to spend this whole trial looking at the back of these guys' heads? Is that what the deal is? It's weird. If we ever had a trial where we're just staring at the back of people's heads, I don't know. I'm hoping they change the angle for the trial.
Sort of citation. I have absolutely no idea why Mr. Wiggs did not actually just give you this Smith versus Carlisle case that he says is from 2024 and instead just gave you his memo about it. But this doesn't even include a site for us to look up. I would ask that any case law that Mr. Wiggs is referencing or trying to have referenced in any sort of legal argument, at the very least, he provide us the actual citation and put it on the record.
It's on the case I gave you, the document I gave you, if you'd look thoroughly through it.
These guys. Yeah, Squeegee, we're streaming this trial. We're definitely doing this trial. Starts Monday. So I think it'll be an interesting one. Yeah, the snarking and the sniping is already tasty here.
The case citation is 378 Southern 3rd 1213. The other decision is cited within it as well.
That's all, Judge.
Yes. The Volcker case is cited right in there, okay, as I just stated. Smith versus Carlisle is the decision of 2024, okay? Now, that's what cites Volcker. It's a 24 decision I pulled off of Florida Law Weekly. It's a current decision, okay?
All right, let's bloop while this dude's looking for shit. Bloop, bloop, bloop. Wait, where's blooping? What happened to the blooping? Bloop, bloop. What? I can't bloop. Oh my God, it's devastating.
I would agree that I could create a summary of Richard Connor and put that into the record as well as to what his take on it all is. So no, it's not appropriate. You're emphasizing facts. Now, the law that he has cited in his motion to grant that is when the parties stipulate these facts are undisputable. Okay, that's when a memorandum or a breakdown summary is appropriate. But those facts are of dispute. You heard Richard Connor. Richard Connor stated that you can't link the IP up with the digital data because it expired. I don't think the state's going to put that in the summary. Okay, Richard Connor said all that data is expired. It can't be linked to a device, a location, or an individual, and that anybody that used a router had access to that same system. But at this stage, none of the data links to an IP address. And so we heard technical testimony on that, of which the state didn't refute at that hearing. I'll point out to the court. I talked to the court and I said, these are the foundations, these are the predicates of which the state offered no evidence how they would try to establish a predicate at trial. So only thing they did is they ushered in a bunch of documents and said, these are a business record. Now they're seeking to develop a predicate through a summary, of which the state just objected to the plausibility of the defense doing the same. So it should be denied.
All right. Any further?
No, sir.
State's motion is granted. The state may admit evidentiary summaries pending proper foundation. We'll move on to number 4. And state's number 4, fourth motion is a motion to prevent exclusion of witness. Please proceed.
Yes, Your Honor, this is pretty pro forma, pretty standard. The victim's father in this case, Laurie Shavers, has requested to be present during the trial. He will be called as a witness, probably towards the beginning of the state's case. The Florida statute that I cited in my motion indicates specifically that the next of kin may not be excluded from the courtroom during this type of trial. So we're just asking that Mr. Shavers, being the next of kin to Michael Shavers, be able to watch the trial.
We don't have, and I know that there's a discretionary concept with that same rule that allows the court discretion in whether to grant it or to deny it. We don't have any problem with Mr. Shaver sitting in during the trial. We would ask the court to instruct Mr. Shaver that he's not at liberty to speak to anybody during the trial about anything that he hears heard within the courtroom. That the rule of sequestration would still be applicable to him, even at the conclusion of his testimony, because we're not going to release him.
All right. As a stated agreement?
Yes.
All right, then, without objection, a motion is granted.
Thank you.
All right, and the state's fifth motion is state's response to defendant's motion for presence of prospective jurors during the entire court diary process. So this goes to Mr. Woods' motion to permit the diary to be present when we are at the bench selecting the jury members.
What I've asked judges that they remain in the courtroom during the entire voir dire. And I've expressed in the motion the basis for this. I know the state didn't voice any objections, saying they'd leave it to the discretion of the court, but the concepts were to allow the witness or the defendant not to be confused, be able to look at the prospective juror to the conclusion, know if they want that witness, just like any witness on the stand has a right to be refreshed at any stage by looking at anything. We'd ask that the prospective juror remain in the courtroom. Second, we've done it historically as a matter of practice. Further, we have the white noise sound system that precludes any invasion or any fear that the prospective juror is going to be somehow tainted by us discussing matters at the bench. So I don't think there's any danger in it. But I think it's a necessity in a trial of this fashion and the size of the jury.
No, I did not ask to leave this at the discretion of the court. I specifically stated that the state requests that you deny their request. Mr. Wiggs definitely seems to have a habit of citing case law that does not actually have anything to do with the issue at hand. For this matter, he has cited cases dealing with refreshing the recollection of a witness, which has nothing to do with jury selection. He has also cited case law about that deals with 3850 claims dealing with whether or not an attorney should have stricken a juror who had, through his statements, shown bias. He does not cite anything that has to do with the issue that he wants the court to do, which would be the rule of criminal procedure, which states that these strikes should be done outside of the presence of the jury. The issues that...
Outside the hearing or outside the presence?
Sounds like this dude's having AI write his brief.
Outside the hearing. I apologize, Judge.
Right.
However, I think it's important to remember that our job here is to maintain the best record possible so that if this is ever transcribed, that the court reporters can go ahead and actually hear what is happening. I pulled the jury selection from the case where this court actually allowed the procedure as outlined by Mr. Wiggs. And I have the recording of that if the court would like to hear it for itself. I would say that it is much more difficult to hear the bench conference when people are whispering and trying to maintain the spirit of this rule while we are up there doing strikes and having the white noise sound played, as opposed to if we were sitting out here in front of microphones and actually establishing what our reasoning for challenges might be and any sort of legal argument that we may have. Any sort of due process claim fails because it is exactly the same for both sides, whichever route we go. But I believe that it is much more important to make sure we have a clear record of what the legal arguments as to any sort of juror strike should be than anything that Mr. Wiggs has outlined in his motion.
May it please the court. Judge, I don't know if Mr. Camuccio just doesn't understand the concept I'm arguing, but to say that the person can be refreshed, yes, that's about a statement that I made in my motion by analogy. No, there's no clear case law on this. There's not. And it's a discretionary matter with the court. I didn't see any case law or any argument by the state otherwise. The legislature has approved this white noise system. If we go by what Mr. Camuccio is saying, we'll just eliminate it, Judge. We'll never have use of it again in a courtroom. But I don't think that's the concept or the principle that the court wants to follow. But I stated in my motion that any witness, by comparison, any witness on the scene.
Go back to the mic, dude. Go back to the mic.
They have a right to look at anything to refresh themselves. So I said, comparatively, by analogy or argument, why is a defendant, why would you take all the jurors out of the room and have a mass of jurors sitting outside when you're doing back strikes and you've got multiple strikes in total and leave the defendant confused? I've sat there and people are asking me sometimes when they are removed from the courtroom, well, what's that person? Who was that person? Was that the teacher? Was that the this, that? And you spend more time trying to keep track of where people are seated, which can raise a 3850. Okay, and I said that in my motion. You got to only greaten the odds that you may have a problem down the line on an appeal because you just didn't impose a safeguard and leave them in the courtroom. So I don't know what policy the state thinks they're advancing here to object to this, but I see that there's a warranted and a healthy process leaving the jury in here instead of returning and seeing it up on an appeal and having to readdress the issue again.
All right, I'll grant defense's motion. I'll allow the Beniri members to remain in the courtroom during the entire jury selection process. Okay, we're on to state's number 6, which is state's motion in limine regarding expected testimony of Adam Arvias.
I don't know. It's irritating me though. He needs to stay behind the podium.
The state motion really focuses on 2 different things. The state opposed the defense listed Mr. Narvaez, and the state opposed him. I attached a copy of the deposition to the motion for the court's benefit. The state's focus is on 2 separate sets of statements made to Mr. Narvaez. The first set of statements are made to him by the defendant, Laurie Shavers. Mr. Narvaez indicated that
Oh, they pulled the shit off.
apply to self-serving hearsay in my motion. This concept would also apply to any witness that the defendant made similar statements to, not just Mr. Narvaez, but because my motion is focused on Mr. Narvaez, I'll limit my discussion to just that. The second portion of the state's motion focuses on statements made by the defendant's daughter, Isabel Shaver, to Mr. Narvaez. As we know, the defense is going to potentially be
Thanks for that, Couch. Appreciate you. Thank you.
that Ms. Shaver, Isabel Shaver, was the one that actually shot the victim.
All right, here we
Ms.
go.
Shaver made statements to Mr. Narvaez years later indicating such. Those are clear out-of-court statements made by a witness, Ms. Isabel Shaver, to Mr. Narvaez, used to prove the truth of the matter asserted, so they are clearly hearsay. By no means is by the state's motion are we trying to prevent Ms. Isabel Shaver from testifying. That's not the focus of the motion. The focus of the motion is to prevent witnesses from being questioned about hearsay statements made by Ms. Isabel Shaver. So because statements made by Isabel Shaver to Mr. Narvaez are clear hearsay, the question is there a hearsay exception to those statements? And the only exception potentially that could be raised is that it's a statement made by the declarant against the declarant's penal interest pursuant to 90.804(2)(c). In order for that hearsay exception to be established, the defense, because they're the proponent of the evidence, would have to present or prove three things. Number one, the declarant, Isabel Shaver, is unavailable. Well, we know that's not the case because Isabel Shaver has given a deposition, and by everything I know, she is ready, able, willing, and is willing to testify in this case. So that prong cannot be met. Therefore, the exception for a statement against penal interest cannot be established. You don't even have to get to the second and third prongs because, again, Ms. Shaver is available. If you
Damn it. Wow. The old mic. I got to get used to the mic. Thank you. So what I was saying is it appears that the daughter is going to testify, at least the way that it looks to me, is she's going to testify on behalf of the state. And during that testimony, she's not going to be saying that she killed Aman, right? That she killed her father, that she shot her father. And what the defense is trying to do is use this older statement that was made a few years back, wherein allegedly she said that she did shoot him. And the state is arguing that in order to impeach her, and I'm talking about the defense, if she's on direct, on cross, they would try to impeach her by saying, oh, well, you're saying this now, but you said this then. So the state is arguing that that doesn't fall within the exception because she's available. She's going to be testifying in court. So, all right, let's see where this argument goes.
You do want to go into further analysis, and we don't need to, but if you did, the statements are also unreliable. Again, I don't think you need to get this far in the analysis, but they are unreliable considering that Ms. Shaver was questioned on several occasions and never indicated this before. There's some scientific evidence refuting her statements, as well as.
It sounds like she's going to be testifying herself, not even this person. So, I mean, like, if they're not going to allow them to impeach her with the prior inconsistent statement, even though it's hearsay, there's no way they're letting the man that she confessed to bring it in for sure. Not a chance.
As the testimony of Jeremy Townsend. But again, I'm not going to go into that really in detail because again, the state's position is Isabel Shaver is available, therefore prong 1 of this cannot be met, therefore the exception doesn't apply and the statements are hearsay. Pursuant to my ethical obligation, there is a line of cases which I included in the motion, which talks about constitutional due process, and that is the Chambers versus Mississippi case. And I included that because I felt the court needed to be aware of it and needed to at least know about it, so I wanted to make sure the court was aware because the defense wants to argue this. But it's important to note the Chambers versus Mississippi case cites 401 U.S. 284, 1973 case. That case addressed a Mississippi case in which a third party confessed to a murder to several people, but then recanted the confession. The state obviously did not call this witness for clear reasons. The defense then tried to call that witness and impeach the witness on the statements he made confessing to the murder to other people. Mississippi had a rule which prevented the defense from impeaching their own witness. Florida doesn't have that rule. So the defense could not get the information that this third party confessed to a murder out by calling the witness and impeaching the witness. So then the defense in Chambers versus Mississippi said, okay, we're going to call those 3 people that the witness confessed that he committed murder to. So they called those witnesses, and the problem with that was it was hearsay, and Mississippi did not have an evidentiary provision allowing, like Florida does, allowing for a declaration against penal interest. So the defense wasn't able to present that information through those witnesses. So because of those voids in Mississippi's evidence code, the U.S. Supreme Court said that the defendant had a constitutional due process right to get the information to the jury, and the evidence code that was in place in Mississippi did not allow that to happen. So what Chambers in Mississippi versus Mississippi basically did was say, on a constitutional due process ground, they allowed those statements, even though they were hearsay, to be admitted to the jury because the defense had no other way of getting that information before the jury. And the U.S. Supreme Court said that's not fair from a constitutional due process. Florida has these provisions, unlike Mississippi. So Florida's evidence code distinguishes Chambers versus Mississippi in that line of cases from the case we have here, this instant case. Chambers pointed out that its holding was not establishing new standards of constitutional law and was not dismissing the authority of the states over their own trial rules. So Chambers didn't find that the evidence code is meaningless and we're going to throw it out and let everything in. Jones v. State, the Florida case, 709 Southern 2nd 512, Florida 1998 case. The court cited Udinas, which was 453 Southern 2nd 17, Florida Supreme Court 1984, which said Chambers was, quote, limited to its facts due to the peculiarities of the Mississippi evidence law, which did not recognize a hearsay exception for declaration against penal interest. So our Florida Supreme Court basically determined that Chambers wasn't applicable because Chambers was meant to fill that void in Mississippi law that Florida did not have. In this case, the defense has every ability whatsoever to present this evidence to the jury, which Chambers couldn't do, but the defendant does because they can call Isabel Shaver and talk about whatever Ms. Shaver wants to say. So that evidence can be presented to the jury by simple traditional methods of calling the witness. The state's focus is, again, not to prevent Isabel Shaver from testifying or limiting her testimony like in that fashion. The state's focus is to prevent the defense from questioning witnesses about the hearsay statements made by Isabel Shaver to Adam Narvaez. Thank you.
Thank you. Mr. Wicks? Yes, ma'am. Please, cool. Mr. Pleasure. We're not offering testimony of Mr. Narvaez to speak about the truth of the statements of Isabel Shaver, but the circumstances under which Isabel Shaver has come forward. There's inferences and allegations that, so to speak, she was called late in this game. The record shows she was not, that Kelly Johnson was appointed as a consequence of her moving forward. Mr. Narvaez, his involvement was he spoke to Isabel and then had a talk to Laurie Shaver, and thus there was a consensus at a certain stage to allow Isabel to move forward with her testimony. Thus, that's how Kelly Johnson got appointed as her guardian and went through the steps that she did. It's just to show a sequence of steps as opposed to putting a witness on the stand as if we've just pulled her out of off the street. It just shows a sequence of events with the timing. It's not to prove the truth of the statements of Adam Narvaez, but to show the timeline and why the minor child stepped forward. That's why. And that's a non-hearsay purpose. You know, it's not to just show that she told me this, okay? It's, you know, what happened beyond that point. So that's the reason it would be offered,
Yes, sir.
which is non-hearsay.
His response?
It's being used, if they're eliciting statements made by Isabel Shaver out of court that I shot my father, that is being used to prove the truth of the matter asserted. That's the whole point of it. To explain the circumstances surrounding it is not a valid purpose. That's like me asking a detective to talk about hearsay because it establishes, you know, that's like me asking a detective, who did you talk to and what did they say, just to establish the context of the investigation. That's clearly hearsay, and this is no different.
The testimony has not been proffered. Now, the state is saying this is what the child's going to say, and this is how she's going to say it. Judge, I think the state is getting ahead of themselves, assuming everything is hearsay that child could say. The context in which the child makes those representations defines whether it falls outside of the hearsay rules. But the state's saying that child told Mr. Narvaez, I did X, Y, and Z, and then, you know.
So the thing about the child when she testifies is that we're not going to see it. Like, they will never allow for a child to get on the stand and testify and allow it to be streamed. So what is going to be the witness that we're all going to want to see, because it sounds like actually the defense is calling her. And I mean, I don't know what she's going to say. I mean, her mother, who is not in custody, who has been out on a $52,000 bond for the pendency of this case, like, I don't know if she's in the care and custody of her mother still. Do you know, Dizzy? I mean, has her mother worked her over to the point where she's convinced this kid, her child, to get on the stand and take the bullet, saying that they're not going to punish you because you were a child? She would have been 7 at the time. DSN. She would have been 7 at the time. This happened in 2015. So, I mean, she's obviously a teenage girl now. Dizzy thinks she's about 16. So, I mean, like, if she's been working her, if Laurie Shavers been working her daughter for the last 2+ years, 3 years, man, and that girl is going to get on the stand and take the hit under the premise that she won't really be punished because, I mean, I think the state, in anticipation of that, has to have some biometric expert that can prove that a 7-year-old, and I'm talking about by the angles of the shots, could not have done it. I mean, I think they have to be able to anticipate that might be coming. That's crazy. That's crazy. And we're all going to be losing our minds because we're not going to get to see that testimony. That's where Brandy Churchwell will come in clutch for us because she's going to be there.
She's offered as a witness. Okay, no, that's not the context in which those statements will come forward. She confided in Mr. Narvaez about certain facts and events. She confided in Mr. Narvaez about her desire to testify and come forward because of her emotional feelings in this case. That's not hearsay. It explains a timeline and why this child is going to be here testifying. That she's not being thrown under the bus, as the state may suggest, but that there's a rational basis and a timeline why she stepped forward.
All right, is there anything further?
Yeah, that seems crazy, right? Like I can't see it either. But
Court finds that
she is presumed innocent.
Timeline is hearsay.
They let her out on a $52,000 bond on a murder charge. This case is not normal.
I believe that leaves us with Mr. Wiggs's motion, which is a motion to request judicial notice and contents of the first file.
Judge, that file just is a standard motion asking permissive judicial notice. I don't know exactly what's going to be presented by the state. You'd ask the state to try to work with me and tell me what exhibits they want to use at trial. Today, I confided with the state whether they would do that. Mr. Camuccio says he hasn't figured that out, so I presume that's a no. Okay, so at this stage, I don't know what the state may show, but it may open the door to the introduction of other evidence. So I'd ask the court to leave that door open for permissive judicial notice at trial.
All right, state's response.
Your Honor, we obviously don't have any issue with the fact that the documents within the court file themselves are authentic for purposes of request for judicial notice, but that is not an avenue for admissibility. Just because it's in the court file doesn't mean you can just say, this is from the court file, so jury, here you go.
So Brandy's connection is that their best friend since college used to be buddies with Laurie Shaver and actually like sat around and drank beer around that fire pit in question. So, yeah, it's crazy. So there's definitely like a 3 degrees of separation type situation there.
As I said previously, Mr. Wiggs does appear to have a habit of, in front of the jury, referencing and marking pieces of evidence that clearly are inadmissible as far as reports and depositions, and then requiring the state in front of the jury to object to things that are just clearly inadmissible. If he wants any of these items marked, or if he thinks any of these things have been opened up the door to admissibility, I would just ask that outside the presence of the jury, that be proffered as to what the document is and the reason for how it is now admissible, simply because it is in a court file or in this court file does not make it evidence in this case. And all I'm asking is outside the presence of the jury that be proffered.
If Mr. Camuccio read the motion, he'd see it's a request for permissive judicial notice, not mandatory judicial notice. I'm not going to be throwing things at a jury judge here. I did ask the court to take mandatory judicial notice of the child's birth certificate, which the child did, which the court did. Okay, this is a request for permissive judicial notice in the event that the door opens. I'm not going to be throwing things at a jury. I would ask the court, judge, can we introduce this at this stage? The state has opened the door on this issue.
Wiggs, get behind the podium, dude.
Right
This guy think he is walking in front of the podium, wandering around.
With the court and with the state.
Oh, to that extent, the request is granted.
Yes. Thank you, Judge.
Is there anything further?
As far as my request that these items be proffered outside the presence of the jury before they're just referenced and marked in their presence. Is the court agreeable to that?
You have any objection to that, Mr. Wiggs?
No, Judge, and I assumed we would do that. You know, I'm not just pulling things out and throwing at a jury. We would discuss it at the.
All right, you already said that, dude. Just say, no, I'm good with that.
I believe that this is all that matters before the court today. Is there anything further before the court?
The judge, yesterday I had referenced the preliminary jury instructions as far as the two alternate portions from the standard that talk about devices. And I just wasn't sure if you had made a decision on which one of those two alternates that you wanted me to put in the instructions to present to you for the preliminary.
Yes, sir.
Well, I can see that, Diz, for sure.
Devices from the courtroom.
He's snarky.
So that would be option B, I believe.
Option B, yes, sir.
Yes, sir. I'll make that change, email it to everyone. I've received Mr. Wiggs's proposed jury instructions, and there are some special instructions in there that we'll have to address at some point whenever the court feels appropriate.
All right, we can address that
Just
prior to trial or during trial.
Right. Just going back, just to clarify the record too, with regards to my motion in opposition to the state's request for a jury summary, in that I had cited Smith versus Carlisle. I had given the state that, and the decision is 378 Southern 3rd at 1213. The state had complained they didn't have a copy of any authority on that. They have it right in the documents that I've handed them as well.
All right, is there anything further?
Yes, sir.
Nothing further, Judge.
All right, thank you all for attending. We are adjourned.
All right. There's that.
The state, please prepare a proposed order concerning the court's rulings.
Yes, sir.
Please copy Mr. Wiggs, and then once the parties are on the same page, please submit that to the scene. Thank you.
Thank you, Judge.
This chick. Good God. It's not like walking out of court. Not a care in the world. Unbelievable. Unbelievable. All right. So, Dizzy, this thing's set to go start Monday with jury selection, right? So what we'll end up doing, I'm assuming that they will not be showing Wardier, however you want to pronounce it. I'm a Wardier guy. But I think even if they are showing it, it's super boring typically, unless you're a lawyer, and then it's kind of interesting. I think for you guys, it might be boring, but we'll keep an eye on it. I'm assuming that the jury will get hopefully picked on Monday. And then we'll start rolling. And I figured a good way to end this live is there's one more little thing I want to share. Who now, Dizzy, I realize that that's Wiggs on this is the weirdest thing I've ever seen. So this is I'm innocent, support I'm innocent by none other than Laurie Shaver, where her and Wiggs have set up this little set on some dock with the water behind them. And let's get a little taste of Laurie Shaver. I think that'll be a great way to shut this live down. You guys ready for this? Let's see who we're dealing with. There's old Wiggs. It looks, I'm pretty sure that's Wiggs. You guys agree that's Wiggs? That's her lawyer. This thing's on YouTube saying I'm innocent. And it sounds like he's trying to get his fees paid with this little video here. So let's see what Laurie has to say.
Laurie at this time.
My name is Laurie Filmer, also known as Laurie Shaver, and as my attorney, Mr. Wiggs, has just stated, he is representing me for the charges of second-degree murder of my ex-husband, Michael Shaver. I'm coming before you guys today just to let you know that we have our suspicions, but I don't know why I've been targeted, why I've been set up, or charged with this heinous crime. I am not guilty. And anybody that knows me knows that my life is my children. I am a daughter, I'm a friend, I'm a neighbor, I'm a servant of God, I'm a wife, and I am a devoted mother of 4. My life is my children. The well-being of my children has and always will be my top priority. And that is the reason that I would never cause any harm to the father of my children. And I know that there's people out there that are trying to paint this picture of me, but that's not me. I'm loving, I'm caring, I have a servitude heart. I don't judge people. I accept all, and I always try to see the good in everybody. And right now, I am
Exactly what I was
up
thinking,
against
too.
something that I would have never imagined possible. And so today, I'm coming to you. My family and I are begging you, asking for your assistance to help prove my innocence in this case. Without you, we don't have the financial means to pay for my attorney's fees. But I can tell you that I am not guilty. I had nothing to do with the murder of Michael Shaver, nor did I have any knowledge of his body being buried under where we were building a gathering place, a conversational fire pit area for our family and friends to spend time together at.
Just in closing, I would like to make a statement regarding attorneys fees, what we're up against. Criminal attorneys are not in that caliber of attorneys that make boatloads of money, okay? That's personal injury attorneys, guys that really have insurance companies to go after. And unfortunately, criminal attorneys rely on people oftentimes with very little funds. This case is probably going to take about 2 years to complete, start to finish. There's going to be a lot of discovery, probably about 50 depositions involved in it, and tons of legal research and motions. That we're going to win this case, but we're going to win it with y'all. If you can contribute to this case, I can assure you we're going to get Laurie out of this mess. So we're asking that you reach into your pocket, do what you can,
What the fuck?
and help us through this. Thank you very much.
I don't think this is ethical. Never in my entire life. An attorney. Client. That is the weirdest thing I've ever seen. But you're watching Kyle TV Live, essentially an infomercial that was made, I think, in 2020. What's the year on this? So 3 years ago, 2021, it's gotten 4,800 views. And it's essentially a lawyer sitting there with his client, hat in hand, begging for attorney's fees. So, I mean, wow. It's gotten, how many likes has this thing got? Oh, I don't think it's gotten a like yet. Is that could that be true? Could that be true? Where's the updates? PayPal, Facebook. All right, so here you go. But in case any of you guys want to send a PayPal to Mr. Wiggs, I don't know, I can't blow it up, so you're gonna have to go find this thing. Laurie's got 18 subscribers, 18 subs, and there you go. So I really, really wanted you guys to sit with that over the weekend. Enjoy that. Think about that. I've never seen anything like that. That was unbelievable. And I just, the ethics, like maybe Florida's like Texas, they're just kind of different worlds. We can never do that in Illinois. We can't even solicit clients like on the phone. Like we can send them a letter. Like if we can go get the arrests that were made over weekends, a lot of criminal defense attorneys do this. They'll find out all the, like, if a DUI guys out there will go run to the court on Monday morning, pull all the arrests, all the dockets for all the arrests on the weekend, get the information. They can send letters out saying, hey, we're DUI lawyers. We see that you got unfortunately nabbed for a DUI. We can represent you. Give us a call, blah, blah, blah. So yeah, weird vibe. But I think I feel pretty good about what we've done here tonight in terms of setting us up for this trial. I think that we have a pretty good understanding of the facts. I think we have a pretty good understanding of the state's case. I think we have a pretty good understanding that she's somehow denying it. It's not clear from that video. And like, I think that video predates. Confirm this with me or not, Dizzy. Does that predate the daughter's statement, or that the statement that the daughter did this? Like, I don't know. Like, how does that video jive with that? So now her story, I just want to be clear. Her story is at this point that she has no idea who did it, who's framing her up. I don't know. Like, I don't know who would have done this. I don't know who would have snuck onto my land and shot him in the house and then buried him on our property. And we just happened to lay concrete there. I mean, it was the spot for a fire pit. I mean, what, whatever. And then, so this thing's out there in the world, but now her story is that somehow she's not aware that her daughter grabbed a gun and shot her father in the house. Like, who buried the body? Are we saying that the 7-year-old dug the grave? The whole thing's insane. So I think we're in a good spot for watching this trial. I think that we've got a very, very thorough understanding of this case. To all my mods, thank you for double duty today. To Dizzy, especially, for all that you do. You're amazing. You amaze me every day. Every day, you amaze me in different ways. You're just a wonderful human being. I'm so grateful for you. To all my mods, thank all of you guys. You guys are all an amazing crew. To Mandy Joe, if you're lurking, if you're watching on replay, thank you for all you do. We love you. We adore you. We got your back, girl. Thank you for putting that nice little timeline together and getting our thumbs together for today. We appreciate you more than you know. And to you guys out there, thank you for hanging with us. And Megan Spit, thank you for your care package. I will certainly be acknowledging in our next live, telling everybody what's in that sweet little package I got. I'm sure it's going to be thoughtful. 'Cause if I know anything about you, you are a thoughtful human being. So I'm looking forward to that. And I did get your email. I'm going to digest it over the weekend. I didn't really get a chance to read it. Been pretty short on time last night. So I will get to that. I'm sure it's amazing. I know that you attached a document to it, which I think is going to be one of the concepts that we're talking about doing. So you guys are the best out there. Thank you, fam. I love you all. Thank you for the support. Thank you for the Venmos. Thank you for the shout outs, the love. Thank you for the supers. Thank you for being members. Thank you for joining if you're new. And remember to like, share, subscribe. And also remember, I'm portaling y'all right over to Steve and Dan for tonight. Feral Friday. Go over there, get down with my boys. Sure to have a great time. I'm going to go hopefully watch the Cheeseheads get their teeth kicked in by the Eagles. So you guys are the best. I love you. I love you deeply. Know that. Feel it in your hearts. I hope that you guys all have a great weekend. And remember, without you, I'd just be an old man talking about a lot of cases. Talk with you next time.